Welcome everybody for our new webinar, Lydian ACC Europe. Today we will talk about cross-border litigation issue and challenges and best practice. And we are pleased to really do our new collaboration with ACC and in particular Bruno Jean-Etienne, who is the co-chair of the Belgium chapter of ICC, and my colleague. And I guess that Bruno, some of the audience might not know which are the ICC association, what do they do, and I think that it's good that you a little bit describe what you're doing in that association.
Yeah, thank you, Annick. Maybe if we could move to slide number 2. So ACC is the Association of Corporate Counsel of the US, and it's really the leading house. It's the leading in-house counsel association in the US, but also in Europe. We have close to 3,000 members in Europe, and really we are aiming at getting together because we want to share the same problematics and also the same type of topics. And in Belgium, and maybe we can move to the other slide. So in Belgium, we have close to, in the Benelux, we have close to 500 members, and all of them are working in medium and large corporation with a connection with the US. And really the aim for us is to leverage, and especially in time of COVID, is to leverage the continuous education. And that's why we partner with a law firm and service provider like Lydian. And in the past, as you can see from the statistic, we used to do more and more, face-to-face event. Of course, we moved totally virtual in 2020 and a bit also in 21, and we are hoping in 2022 to come back with more in-person event because we know that it's all about knowledge, but also about networking. So that's really the aim, and I think the topic of today is it's a nice topic because it's always, at least as an in-house counsel, you're always struggling when you see a claim or a litigation topic into a very obscure country, and you have to do something because you have to protect the interests of the company. Next slide. And then why, and as Annick was explaining, we decided to partner with Lydian because Lydian is really a well-established independent Belgian firm, was awarded an award in 2018 from the Trend magazine, and we really partner with the litigation team because they have a lot of cross-border experience. And we, as ACC Corporate Counsel, we always have issues where we have impact in not one country, but sometimes in several countries, and we will see that in a few minutes. So today with us, we have Hugo Keulers, which is the head of the litigation practice, with a specific focus on insurance and reinsurance. And he's also, at the moment, the managing partner of Lydian. We have Willems, which is also part of the litigation team. He's a bit the young guy on the block because he's going to become partner in Lydian on 1st of January 2022. And we have Kim, which is a senior associate with Lydian. And organizing and also sharing the meeting, we have Annick Mottet, which is a partner also at Lydian, more focusing on IP and distribution issues. So with that, Annick, I will give you the floor for this interactive session on cross-border litigation, and all we go.
Yes, thank you, Bruno. A few more practical insights for the participants. We will address all the questions at the end of the seminar, just to make sure that we are online with the timing. And also for those who need for the permanent training certificate, we will have kind of a poll question during this seminar, and so that you can reply, and then so that if you reply to all the poll questions, then we can issue a specific certificate for you, which will be sent by our Stephanie, which is behind the scene and you don't see, and I thank you already for her collaboration on that webinar. And then also another practical, you have, I think, in some of the box down to your screen, you have also the possibility to download our presentation. But let's go directly to the subject matter. In fact, we just noticed recently that more and more we are confronted, not only legal counsel, but also lawyer, with an increasing number of cross-border issue. Of course, it's normal in a global world. And so that's why we have decided through a case study to just explain the best practice and challenges. And so let's talk about our case. It's a little bit of fake, but based on the experience that we had. And let's take, of course, a Belgian company which is specialized in the supply and manufacturing of chocolate. And this company has ordered some filter in Germany in the process of making the praline, and then it distributes the praline also to Spain, basically. And what happened in Spain is that some customer just noticed that there was some iron particle in this praline, and so of course the Spanish company just filed a claim against Belgium, and then the Belgian company just discovered they proceed with a root investigation, and they just discovered that in fact it was something with regard to this filter, and some particle just happened to lose. And so basically you have a set with all complicated facts, and not that complicated. If it will be more complicated if you add, for instance, that some batches of praline were sent to the US, so that you have another system involved. And so, Hugo, can you tell us what is your first reaction when you see such a kind of a deal coming out?
Well, thank you very much, Annick and Bruno, for the kind introduction and for introducing the subject matter of the case to all of the participants. I think if you are becoming aware of the emergence of a claim against your company as an in-house legal counsel, you are probably from the outset are going to identify who may be the parties who are involved in the situation, both on the output side and on the input side. Because that is going to be relevant and important to know against which parties eventually possibly litigation may have to be conducted. And in order to do that exercise, you will have to reach out to your colleagues, and probably you know better than I that this is sometimes a very time-consuming exercise, which is not that straightforward as one would think, to dig up all of the relevant contractual documentation and information that is available to not only identify the parties who are involved, but also to determine the applicable contractual framework. As we all know, it is rather an exception and seldom that you will find a proper signed and executed framework agreement between two parties, even if these are large companies and big businesses. More than often you will find that there is a spread of documents starting with a price quotation, followed by delivery or sales confirmation, and then subsequently there is an invoice, and on top of that there is some reference to general terms and conditions, which may either or not just be somewhere printed on a website, or sometimes also printed on the backside of the invoice. And it's in particular when you have these contracts where there's only a sort of exchange of these commercial documents with reference to general terms and conditions that pose a difficulty. Because take the example of general terms and conditions that are just printed on the website of a company. The question then rises is that enough to be applicable on a contractual framework? We know it can be enough in Germany, for instance, but we also know that with the rather formalistic Belgian case law, it will not be enough, because you will have to demonstrate, when you want to rely on general terms and conditions, that you have transmitted them, handed them over to the other side prior to the conclusion and the entering into force of a contract. And there is no uniform European law on that. It's not regulated in an EU regulation So it's still left over to the freedom of the member states. And I understand, Bruno, that US in-house legal counsel has had a particular experience in that regard that you want to share with us.
Yes, Hugo, indeed. For me, luckily, at least in continental Europe, in code civil countries, there is no really full discovery, or you don't have to disclose all of the document. But what I will often do is ask the team in all honesty to do, I will say, an internal discovery. So at least we want all the document to be on the table. And then sometimes not to be, because sometimes when you are dealing with, and I know it's not the case at Lydian, but sometimes you will have a counsel, which is sometimes maybe a barrister or someone only focusing on litigation. He will really look at the black letter law of the T's and C's and will come up with, okay, we have to do this and that, etc. But what I will challenge him is to say, look, let's try, because sometimes we also realize that the document system, and nowadays with the retention rule on email, a lot of people are losing a lot of document. On top, if you work from home, etc., you may lose some commercial document. So technically, it's not because we have those documents that the other party will have it. And that's why I will also try to do a bit of a strategy with our litigation lawyer to make sure that we are selecting the most optimum forum for us, even though I will say the supporting documentation might be 85% okay supporting that. And let's see what they do in reaction, because they may have no, if you lose a laptop, if you have a crash of a computer or a server, you might have no documentation. So let's see effectively, let's move a bit hidden and see what is the best forum for us. We try to do it. If not, we still have a fallback. But that's a bit of the way. So let's not always be focused, on when you are driving, you have to look far, because if you look on the small point of the T's and C's, you might be derailing. So that was a bit my take on that, Hugo. The floor back to you.
So
thank you, Bruno. Oh, sorry.
So basically, what then, Hugo, you will do in this present case? And
well, I just wanted to say that I like what Bruno says in his approach, that you really from the outset have to think in a litigation situation about strategy. It's not about mathematics. You will never be 100% sure about a situation. You will have to work on the basis of probability scenarios. And in the probability scenario, you will have to follow the best possible strategy to defend your case. But obviously, to some extent, as lawyers, we know that we will have to rely on the contractual documentation. And rather than to look at the content clauses, such as liability, limitation of liability, force majeure, we will, in a cross-border situation, in particular, focus on the clauses that deal with applicable law and dispute resolution. And in the case that we have here at hand, Annick, we have found out that the situation between the Belgian company and its Spanish purchaser is completely different from the situation between the Belgian company and its own German supplier of the filters. On the one hand, with the Spanish company, there is no framework agreement. It's an exchange of quotations and other type of documents. But with some analysis, we have to conclude that it's very likely that this will lead to Spanish jurisdiction with the application of Spanish law, whereas in the relation with the German supplier, we have a far more comfortable position from a legal point of view, because there we have a signed and executed framework agreement providing for SEPANI arbitration in Brussels and the application of Belgian law. Now, I hand it over to you now to deal with the poll question, Annick.
yes. Because in fact, we would like to know, in fact, seeing a little bit what is your experience with this, and to know, so when you are confronted first with the analysis of your such a litigation issue, what will you do? Did you do it yourself as a legal counsel? Do you ask your external lawyer to look into the matter, or do you both check? So it will be interesting to see the poll. I see that there was a lot of participants. Still people voting. Okay, I think that Stéphane, you can share the results, and then in fact we see that basically most of you will basically do both, and of course first an analysis of the situation by yourself in-house, and then at the second point you will double check with your lawyer, and it seems obvious. But then it seems also obvious, Hugo, that the second issue, of course, is to put legal team or litigation team, and so this is really the second key point to consider when dealing in cross-border litigation, I think.
That's absolutely correct, Annick, and especially when you have liability claims being formulated against you, it doesn't even have to be a writ or a lawsuit. You always need to have as an immediate reaction as well to inform your insurer. Most of the companies today have product liability insurance to the extent, like in a case like this, that there may be bodily injuries, perhaps. You are going to notify and warn your insurer, because your insurer obviously has not only an interest to be aware of the existence of the claim being filed against you, he even has some controlling powers over the litigation strategy that will have to be conducted. That is one important aspect. Apart from that, doing a major litigation where you have to defend yourself on the one hand internationally and fight on the other hand as a plaintiff requires you to put together a sort of international team, like you also would be doing in case of a cross-border acquisition or a cross-border M&A process. And you need to do that early on in the case, even if you're not yet sure whether you will need foreign legal counsel very intensively, and you not yet have any concrete instructions, because it may happen that in a month or in 2 months' time from now, when you don't make progress in conducting settlement discussions or in exchanging technical information, that suddenly you may be sued in a foreign court where you have to take position in only 3 to 5 days or so. And if you then only will start with the process of identifying and selecting your appropriate and your legal partner in that particular jurisdiction, then that may come too late, and you will no longer be in a position that you can select and identify the best placed lawyer to assist you. Now, yeah, we have quite a lot of...
And some of our colleagues, in fact, I remember in Croatia that they just were surprised that in Belgium it was taking so much time, that we have exchanged long process, and there that you had to be on spot within one month. The case has to be ready to court. Yeah.
Absolutely, it can sometimes be very quickly in certain scenarios, and you need to be ready. Now, how are you going to approach a situation like that? I think there are many sources on which you can rely as an in-house legal counsel. There's obviously the guides like Legal 500, Chambers, Who's Who Legal, but in my mind, they only give you a sort of a long list that you can look at, which you will have to narrow down in the second step to a short list. And the narrowing down probably will have to be on the basis of experience of people. And if you don't have the experience yourself, you may question your fellow colleagues, members also of ACC, for instance, in-house legal counsel, because there, I think, Bruno, that an organization like ACC really can provide added value to its members. But you can also question your own domestic local counsel, legal counsel. Maybe he has, in these obscure jurisdictions, he has a partner firm, or he has worked there together with independent firms. All of that, the insurer itself will also have to be involved, because it's very likely that he may have to pay the bill of the foreign lawyers. So he wants to be involved as well to make a choice. And all of that information will bring you to a sort of shortlist. You'll use that shortlist then to set up interviews. And I insist on that. Never appoint a foreign lawyer in an important case without having interviewed him. And this can be perfectly done. I've done it tens of times in the pandemic with WebEx or with Teams. It will give you essential information, not only on the experience of the lawyer and the expertise, but also on very important things such as how's evidence gathering taking place in your jurisdiction. Kim, I believe, will talk about that later also in that presentation, because evidence is everything. If you're a defendant, you don't have the burden of proof. You can sit back and see what is the evidence that the plaintiff will bring to you. And once you have conducted the interviews, you will be in a position to appoint foreign legal counsel. If you, again, even if you don't have immediately instructions for them, you at least have reserved your position with them. You are sure that this counsel can no longer be conducted by your opponent. He will be conflicted out for your opponent. He must work for you, and your team will be ready once there will be a lawsuit being filed against you. So I conclude there, Annick, and I leave the second poll question again in your good hands.
Okay, so we will go through this question, and it's a little bit to share in the presentation. It was nice in preparation of this seminar. We discussed with Bruno Jean-Etienne what was his practice, and we will see, Jean-Etienne, Bruno, whether your colleague has the same aspect or view on this. How do you select your foreign lawyer? Do you take advice to your domestic lawyer? Do you look in the guides? Do you use an international network, or do you refer to advice from colleague or other possibility? That would be interesting, and I see it will be interesting to see the result, because we invest a lot of time in these legal guide and submissions. So, and yes, obviously it's not the first results that we get, so that we can relax a little bit and not be too involved in the preparation of this submission, which is quite time consuming. I think that we can share the results, Stephanie. And then, of course, we see that basically you rely on your domestic lawyer and you rely on your colleague, which is obviously also a strategic and a wise decision, and that's what we would do also from experience. But of course, that once the litigation team has been set up, and so I think that the next point, the next key consideration to take into consideration, basically it's really to set up the communication between them. And then I think that you are best placed to share with us your experience in this matter.
Yes, thank you, Annick. A basic point to consider is, of course, and a very important point, is the communication, but for sure in litigation, and especially in the settlement of the possible settlement of negotiation, is the confidentiality of communication already from an early start of the litigation, or even at the start of the dispute. And it's both internally within the business with your sales manager, but also on the board level, but also externally in the communication with your private experts, with the court-appointed experts, the foreign lawyers. There the communication should be, or at least you should try to keep the information confidential. So to start the communication between the parties, that's the most essential, is in principle not confidential unless the parties concluded a separate agreement on such confidentiality of communication. But please note that the fact that your agreement contains a confidentiality clause or an obligation does not necessarily mean that the correspondence that you will exchange in negotiation in a dispute will also be confidential and privileged, even if you put on or you mention that it's confidential and privileged in your emails, or that you have other mentioned in the emails. That will not necessarily result in the confidentiality of communication. So you will need a new contractual framework to safeguard the confidentiality of the communication. between the parties, which will be, of course, very difficult in the context of a litigation, or even impossible to achieve, because the parties will have to, again, agree on it. And in a litigation context, to reach an agreement on the confidentiality will be very difficult. So in the case study, when we go back to the case study, I think that the Belgian company will have to be very careful when sending out any communication, not with the German supplier, because there the liability is on the part of the German supplier, but especially in the communication with the Spanish customer, because that can be used against us. An email from a sales manager or purchase manager can be used against the Belgian company. Then the internal communication is also not confidential. But there's an exception, an important exception, I think, for the audience today of legal counsels. Under Belgian law, at least, we have the exception for the legal privilege of legal counsels, which is laid down in the Belgian Act of the 1st of March 2000. And this is establishing an institute for company lawyers. And there in this act, we have an Article 5 that stipulates that the opinions given by the in-house counsel for the benefit of his employer, so employer is an important word, and in the context of his function as legal counsel, are confidential. So there are several conditions for the communication sent out by legal counsel to be confidential. Is that he is a certified in-house legal counsel, so a member of the Institute for the Company for Company Lawyers, and has an employment contract giving legal advice to the employer or to connected companies. So there will be no confidentiality when the employer decides to send out the advice to a third party. Of course, it will be covered by the professional secrecy of a Belgian lawyer or a foreign lawyer. That's not the case, but that's, of course, important to note. This legal privilege of the company lawyer has also been ratified and accepted by Belgian case law, which also confirms that there is a legal privilege. There has been now a bill of the 7th of January 2021 of this year, early this year, which has also extended these rules of legal privilege to self-employed legal counsels. That's something important to note. And also the scope of confidentiality, when it was first not clear what was now the provision of opinion. Now it's clarified. It's all information obtained in the context of providing legal advice, but as well as the advice on starting, following up, or avoiding legal proceedings. And it has also been confirmed that this confidentiality or this legal privilege is also opposable against government bodies, for instance, competition authorities, which is very important. This is also confirmed, at least under Belgian law. Then we have also, of course, we don't only have communication between the parties or internally, but also the communication between the client and the Belgian lawyer, and this is confidential. The Belgian lawyer, in fact, is bound by professional secrecy, and he does have to respect that, because otherwise he will face criminal sanctions. On the other hand, the client, who can rely on the professional secrecy of its lawyer, the Belgian client, or the client of the Belgian lawyer, he can, of course, decide to produce any correspondence with the Belgian lawyer in court proceedings. He's not bound by this professional secrecy. The communication, and that's important in case or in the context of settlement negotiation, communication between Belgian lawyers is confidential. And this is very useful, like I said, for settlement negotiations, because then you can use the correspondence between Belgian lawyers or meetings, phone calls between Belgian lawyers, also to conduct confidential settlements. There are, however, exceptions. For instance, if the Belgian lawyers, based on the instructions of their clients, would reach a settlement of the case, then the communication between the Belgian lawyers will become official. Often what we do is to also add a disclaimer that it is subject to the conclusion of a formal settlement agreement. So without having a formal settlement agreement in place signed by the parties, also then the communication between the Belgian lawyers will still remain confidential. And another exception to the correspondence between Belgian lawyers is also official communication, like a notice of default, so this or the termination of an agreement. That's like giving a notice period, sending out a notice period. An NDA, as I said before, can also be useful, but when you're in the context of litigation, it may be useful to convince all the parties to accept an NDA. In our case study, I think that the Belgian company will be very keen to have an NDA signed, but a penalty also for violation of any of the NDA. But I think that the Spanish customer will be very reluctant to sign such an NDA, as it will try to use all communication and all evidence in proceedings before the Spanish court. Confidentiality of communication is, of course, very important in settlement negotiations. What we often see is that in court proceedings, that there's made a reference to an email sent then by someone of the business who already acknowledged liability or made a proposal to remedy a situation. That's, of course, very important. What you need to watch out for in confidentiality of communication is that there is something, the communication between Belgian and EU lawyers is not confidential unless the confidentiality of the confidential nature of such communication is previously communicated by the sender, for instance, the Belgian lawyer to a Spanish lawyer, and the Spanish lawyer has to accept the confidential nature before the Belgian lawyer can send something to the Spanish lawyer on a confidential basis. So there it's not the same as in Belgium, and you have to ask the other lawyer whether you can send something confidential to the other lawyer. Also, communication with a court-appointed expert and or third parties like a broker, for instance, is not confidential. Often parties seem to forget that. And last but not least, and that's what we often see, and that's what I started also in the communication between the parties, that you see catchphrases originating not from a civil law system, but usually from a UK or common law system without prejudice on letters, or that's usually a translation of under reservation of all rights. Now, the without prejudice mention in letters, unfortunately, only has a specific legal privilege protection under UK law, not necessarily under all the legal systems, particularly not under Belgian law. So the local lawyer is very important, that they must advise clients how to safely negotiate or send letters under the rules of the competent courts. This will be their courts. The without prejudice under UK law means that the correspondence can not be used afterwards in litigations if the negotiations have failed. And this is opposite to the without prejudice save for cost under the UK law, which means that the correspondence cannot be used in the litigation to determine liability and compensation, but it can be used by the courts to allocate legal fees over the various parties in a dispute under the UK law. And in the UK or in the US, a party can indeed be convicted to pay all the lawyer's fees, or the winning party is entitled to recover its lawyer's fees. That's unfortunately not the practice in Belgium, where you can only receive a limited compensation. And the decision by the court is then often based on the proposals that parties have exchanged before litigation started, under the cover of such without prejudice save for cost letters, and then the court can take into account these letters and then allocate the fees based on the respective proposals. So summing up, the key point of the confidentiality of communication: be aware that especially your external communication will not be confidential by definition, that the wording without prejudice unfortunately will not protect you or will not be sufficient, and that you need the intervention of a lawyer. In Belgium it's easy, then the correspondence is confidential, or a new contractual framework, an NDA, to safeguard the confidential nature of your communication.
Yeah, thank you. You're in fact, and I noticed that in some of, I had recently a case where the American just say, yeah, but I just wrote in my email that it was for discussion purpose only. And of course, then the court say, okay, it's only for discussion, but then in the fact, if you had executed according to what you say in your letter, it may give a hint to the court. And then, of course, you are the slave of what you write and what you say, but you are the prince of what you don't write, do not say. Or you use a lawyer and make sure that via this channel, everything is really privileged and confidential. And so as a next question, it would be interesting to see what is your practice as an inside in-house counsel, whether you, for the communication, you prefer to keep direct contact with the party and maybe sign an NDA, or whether you have your communication through your only your lawyers, or do you use this catch-all sentence, or you combine everything? I guess also it depends also, I guess, from the circumstances, but it will be nice to see what is your practice and whether we can draw any conclusion regarding this issue. And then maybe I think that everybody has voted, and we can share the result, and we can see that basically most of you are using all these communication mean, and probably the communication between lawyers, it's still quite important, as well as make sure that NDA, I mean, usually it's also a good, so you are cautious, I would say, in your approach, and you are, you want to add something, Bruno, or it corresponds to what?
I'm surprised with the very low amount for the with privilege or the stuff you put on the line of the email, because it's true that it's something that, especially when you work cross-border with our US colleagues, it's something that you see much more on US email that are either traveling through the US or going into Europe. So we tend to, given that we are most of us are non-native speaker and not really knowledgeable of the other side of the pond in terms of legal system, we tend to effectively copy paste what type of stuff the US colleagues will say. But it's true that at the end of the day, it's best also to have, I will say, some tools and wording that are operational within the jurisdiction you are going to litigate or where you are operating. Also, I will also say that our business people love those kind of small legal catch-up phrase. So sometimes they will send you a normal email, but they will put all the privileged legal stuff. So, but I guess it's the best way. As,
confidential, yeah.
Voilà, because as an in-house counsel, we are also there to risk manage the risk of the company. So also, the more I will say our business people are aware that there might be a risk, it's a good way, because the more they are trained, the more they will react in the proper way when there will be effectively a real risk. So that would be my take on that, Annick.
Yeah, thank you. And of course, now that we have seen that we know communication is important, but also as a key point to consider in dealing with cross-border litigation is also the use of the language, and sometimes we forgot about it. So share with us your experience in that.
Yes, and I think this is also a basic point when you have then the communication. First should be confidential, but also the use of the language, and from the very start of the litigation, also both internally and externally. While it can be when you're communicating internally in a specific language, which is not your native language, it can be somehow artificial. But yeah, sometimes it's necessary to prepare for litigation in English, and therefore also communicate already internally and externally with your local expert. Even if you have a direct relation with your local expert in Belgium, it could then be that that communication should be or is in Dutch or in French, that you ask him to draw up a report in English already to prepare, for instance, arbitration proceedings, which will be conducted in English. The same goes for foreign lawyers, although there, of course, what we see is a more market practice to communicate in English with foreign lawyers, certainly in cross-border litigation. Please note, of course, also that the jurisdictions, and I think that's important, may have strict legislation regarding the use of language in judicial proceedings. For instance, in Belgium, the Belgian proceedings must be conducted in the language of the jurisdictional region. And to make it very complex, we have 3 regions, so the proceedings should be conducted then in Dutch, French, or German. This is a matter of public policy, mandatory rules. So the court will impose those rules, and we will have to file, for instance, written pleadings then in Dutch or in French, and also the oral pleadings will take place in a certain language. But of course, what's more important, not only the written pleadings should be in a certain language, which we will then have to provide for a draft, but also the exhibits. And the exhibits should also be in the court of the language of the proceedings. Although we see that, for instance, exhibits an agreement in English or in French, that it's usually also accepted, for instance, by Dutch courts, that should not be translated. But if you have an adverse party who insists on the translation of the exhibits, then it can be a substantial and significant cost if you have to translate, for instance, an EPC agreement of 500 pages with all technical exhibits and annexes. So this is something that you have to take into account, not only at when the litigation is conducted, but even when you have a contractual framework, that you also look at, for instance, or envisage to include an arbitration clause that the proceedings can be conducted in English. The arbitration proceedings in Belgium can be conducted in English, if of course stipulated in the contract, but unfortunately you cannot stipulate in an agreement that court proceedings should be conducted in English. That's not possible anymore. So what we there have to watch out for is for the translation cost and time, not only for letters, procedural documents like written pleadings, but for instance also for other contracts, technical notes which have to be translated, which is very time and cost consuming. So the use of language and the choice thereof from the very start of the litigation is very, very important, and it can have a significant impact on timing and fees. So be aware of that before you start litigation, but even better before you enter in a contract. That's the summary I want to give.
Yes, thank you. In fact, I remember that I won several cases in patent litigation just because I have asked translation. They were a company alleging counterfeiting or infringement of its patent, and the US patent, and they have filed a folder of patent, everything in English, and we were in Mons, south of Belgium, and I just say, yeah, sorry, but we don't speak English here. And so basically they never filed the translation, and the case just ended like this because they did not have the resource to proceed with translation. So yes. We would be interesting in knowing what is your practice, what is your, as a new poll question, whether you, when you are confronted with cross-border litigation, whether you communicate directly in the native language of the court, or do you use English, or basically you never thought about it and you did not thought that you will be confronted with this issue, no preference. But of course, with ACC participant mainly, you are a very large international audience. So of course, when we see the result of the poll, basically it's mainly and basically principally in English that you communicate, and I think that in our everyday work that is a basic language, I would say. So that now we are we have the language, we have the team, we have everything ready, but most important things that we have to tackle, it's of course the gathering of evidence. And here Kim just remind us what are the best practice and what are the challenge, and if you have any tips for our audience.
Yes, thank you, Annick. Hugo actually already introduced this topic a little bit when he was talking about forming the legal team and the expert team as soon as possible. This is indeed quite important because today evidence collections rules, they are still national law, so there may be some important differences in various jurisdictions. Obviously, you have the difference between common law and civil law on one hand, where in common law evidence collection is much more a responsibility of the parties itself. So the judge or the court will have a more passive role. In civil law jurisdictions, the judge may be a bit more active, for example, ordering court expert service and things like that. But even in common law jurisdictions, or excuse me, in civil law jurisdictions, there may still be some differences between national law. So it's important to contact your foreign lawyer or your foreign counsel as soon as possible, so he can help you already with explaining the rules on evidence collection, so you can get started early on. There is EU legislation regarding collection of evidence, but it only relates to facilitating cross-border evidence collections. So what the EU regulation foresees is that, for example, a Belgian judge can ask a French judge to help with evidence collection by, for example, hearing a French witness in France, so that the Belgian judge doesn't have to do this. This is a possibility, but it does not harmonize evidence collection rules themselves. So it is important to be aware of the difference that you may encounter, for example, regarding expert opinions or expert service, which are a very important aspect of evidence. As soon as there is a technical aspect concerned, for example, in our case study, when there is a problem with the filters, the question will be which party, if the filters were defective, yes or no, so that will be important. Also, the calculation of the damages may be important and may need the help of an expert. In civil law jurisdictions, you may think perhaps that contradictory expert service are the rule, but this is not the case, because even in civil law jurisdictions, there are some jurisdictions, such as, for example, Spain, which actually prefer unilateral expert opinions. So they also follow a bit a common law principle that parties have to deliver their own expert opinions, and then these experts may be cross-examined, but the court itself will not order, or only in very limited cases will audit a court expert survey. So in Belgium, the principle is more that there will be a contradictory court survey and court opinion, expert opinion, and that the court will sort of follow up on it, but it's definitely not the case all over Europe. So it's important to keep that into consideration. Also, an important, unfortunately, an important aspect of expert service are also obviously the quality of the experts. Sometimes this may be a problem in Belgium. Sometimes the court experts aren't the best placed or the best specialized in a specific matter, but it is usually, even though the expert opinion isn't legally binding for the court, in almost all cases the court will base its decision on the expert's opinion. So it's something to keep in mind. Apart from expert opinions, there are other useful evidence means, such as, for example, obviously the contracts, the emails that have been exchanged. Like Bruno also mentioned in the beginning, even though there is no formal disclosure proceeding in civil law, which I will also discuss a bit later on, it may be useful to have an internal proceeding of disclosure, so you know what kind of evidence you have, and maybe you can already anticipate what the other party may or may not have, and which they can use against you. So that is definitely important. Also, witness statements, if you can collect them, this may be useful. We also mentioned legal opinions, especially when it concerns foreign law, because you may be you may be involved in a proceeding, for example, before the Belgian courts, but there may be some aspects of, for example, Spanish law that apply. So in that case, the Belgian judge will have to apply Spanish law. Obviously, these are judges that are also schooled in Belgian law, so they are not experts on Spanish law. And even though they are, the law states that the judge has to apply the foreign law, so it's not technically the responsibility of the parties to prove the Spanish law principles. It may be very useful to use legal opinions drafted by Spanish lawyers, which can help you convince the judge of the Spanish law and of the fact that you are in fact entitled to, for example, a compensation, because that will lessen the burden of the Belgian judges' responsibilities. So this will definitely be helpful. Like I mentioned, there is no formal pre-disclosure, pre-trial disclosure or discovery in common law jurisdictions. This is very common in common law jurisdictions and not in civil law jurisdictions. This is something to watch out for, because obviously you may still be involved in a proceeding for UK courts or US courts, and then you may have to disclose all the documents that you have internally. So our next poll question is actually to ask whether this is something that you have been involved with in the past, yes or no, because it's something, even though it's not a common law principle, we understood also from Bruno that if you have, for example, a US mother company, this is something that you still have to work on. So that's why we ask you if you have been involved in such a proceeding, yes or no.
Yes, it's quite interesting to know that. Yeah, I also win other cases just on the basis that cross-examination from, it was a commission rogatoire from the US, and basically the Belgium just started to handle it as he was happy to be in the like in the US court, and then after 2 days of cross-examination of the Belgian witnesses, the parties settled the matter. And so basically, most of you have not yet been confronted with these pre-trial disclosure proceedings, and it might be useful to take into consideration this aspect, and also to when you have the possibility to have a litigation that there is a risk where you will have aspect of US or UK, it's really also to settle in your communication, really save all the document, really set up guideline, ask your US or UK lawyer just to provide you with the guideline, just to make sure that as of the start of the pre-trial, I would say, you are ready to face these specific proceedings aspect that we are, as a common lawyer, not very familiar. I guess that, Bruno, you have been involved already in some disclosure, pre-disclosure.
No, luckily not. But it's true that we've seen, or at least on the fringe of it. But it seems to be, when I discuss internally with my US colleagues, is effectively something which is pretty cumbersome and very, very tedious to handle. So it's a bit of, so as you said, it's not, the 75% of us, not yet, but the more the economies are intricated, the more it will certainly come. So that's why I always like to, I will say, to have, let's put everything on the table, like an in-house discovery methodology, not as aggressive as it would be under Anglo-Saxon rule, and then we'll take it from there, basically.
Okay, thank you, Bruno. And I see that we are getting close to the end of our seminar, but we have quite an interesting question coming up. So I think that first we want to really summing up what we have learned from today, and I guess that the best place to do this summing up is Hugo, with your big experience in the matter.
Thank you very much, Annick, and also to you and Kim. Yes, we have retained 5 points that we wanted to insist upon from a practical point of view. First of all, as Bruno indicated as himself as well, especially if you're confronted with a major dispute coming up, make your inventory of everything that is available within the company in terms of contractual documentation and information, evidence, potential evidence about a case, and make an assessment as soon as possible in the process on what may be the applicable dispute resolution mechanism and the governing law, because that will dictate a great part of your further strategy. That when you go to war, secondly, you know that you have to go to war with the right army and the right weapons. That is why you have to put immediately focus on the formation of a legal and expert team, also in these jurisdictions where there may not yet be a perceived immediate need for assistance. I think you should do the probability test, and when you pass the probability test, you will have to find suitable legal advisors and experts who then also will have no conflict of interests when you need them. Jo has very rightfully insisted on the importance of confidentiality in exchanging documentation, both internally and externally, and especially when it comes to the exchange of settlement proposals and counter proposals. Be mindful of the fact that a confidentiality or without prejudice language will not necessarily protect you, will not necessarily grant privilege to the correspondence that is exchanged, so that it may bite you in the ass, as they say afterwards in litigation, when you fail to reach a settlement. Communication is key. Therefore, also the language in which communication will be conducted, where you will have to find a balance between the cost price of the whole process, the efficiency of the whole process, and tactical reasons or justifications that may exist in favor of one language or the other. Remember the example given by Annick before the Court of Mons, where she was basically able to destroy the case of the opponent by simply insisting that they would provide French evidence or French translation of the English evidence available. If you create a burden on your opponent by throwing this sort of defenses, that may sometimes be extremely effective and something that you should not ignore in your legal strategy. And finally, engage foreign lawyer early on in the process, because early on in the process you probably will already start thinking also on the potential of settlement. We see that in practice, that the settlement potential is explored much sooner than it used to be 5 or 10 years ago. But that also means that you need to have a clear understanding how the rules of evidence in the applicable dispute resolution mechanism will apply, and how strong or weak your position may be in terms of evidence. I think these are the 5 key points that we would like you to take home. But I think, Annick, there may be further questions from the audience that we will be gladly to respond now.
Yes, we are happy because sometimes we don't have time. So here it was really helpful, Bruno, to add this 15 minutes to our seminar so that we could answer some of the questions. And one question, Hugo, is for you. It's basically when you have in the insurance matter, usually you have also to collaborate with the insurer lawyers, and you are on the same side, but sometimes you have different approach, and so how do you coordinate, and how do you, is there any specific tips or challenge in this regard that you may share with the audience?
Yeah, thank you for that, Annick. And it's a very legitimate question because especially in the major claims, that is something that bumps up on a regular basis because obviously the insured often has an important commercial interest in preserving a relationship with the party that is making the claim, and therefore is hoping and expecting his insurance company to be rather flexible and accommodating in reaching settlement and paying out compensation. But for the insurance company, obviously, the approach may be completely different, and they have to take into account other stakeholders, such as their own shareholders, or sometimes even reinsurers. I think the right answer to the question is a combination of transparent communication on the one hand and diplomacy on the other hand. You try to strive to keep the interests and the positions aligned to a maximum extent between the insured and the insurance company. That's also what the insurance company, if they are your client, want to have, without obviously ignoring the areas where there may be a conflict of interest between both positions. And when there is a conflict of interest, I think you have to flag it. Don't let it rotten, because then it becomes unmanageable. You have to put it on the table as quickly as possible and bring the parties to the table to discuss it out and see how they can accommodate each other. I also think that insurance brokers have an important role to play at that moment. Usually they will be sitting at the table as well. And in my experience, when you follow that pattern, most of the time, it is possible to find a compromise, also because most of the industrial risk insurers that are on the market available today, these people, they understand business very well as well. They understand the importance of commercial relationships. They are themselves in a commercial relationship with their insured, and they are therefore willing to take into account the necessities or the needs that may arise out of the commercial context within, of course, always certain boundaries, but these can be discussed, and in my experience, they should not lead to a conflict between insured and insurer necessarily.
Yes, thank you. And another question which was raised by the audience was relating to the expert. We talk about lawyer, legal counsel, and of course, if you have a proceeding with some technical issue, you will have to rely on an expert. And basically, it was relating to whether what happened, because if you have a foreigner expert coming into Belgium, or if you have as a cross-border litigation, you have Belgium expert, but they require information from outside. So I have been involved in a design infringement case, and in fact the Belgium didn't see any problem to go to the Netherlands. Okay, it was not that far, hopefully, and then to investigate and to go to my client to make the report and to examine the exhibit and so on. But of course, there was some rules. Jo or Hugo, you may add something from your experience, because you have a lot of expertise in your proceedings usually.
Jo, please go ahead.
No, I think also, yeah, the question was whether the court would appoint then a foreign legal expert to serve as a court expert in Belgian proceedings. I think my personal opinion is that a foreign expert of another nationality can be appointed by a Belgian court. But of course, this foreign expert will have to respect also the Belgian procedural rules on court expert proceedings, which are quite specific. You will have to ask the court if there is an issue between the parties within the Belgian court proceedings, and also the gathering of evidence. Although these legal experts will maybe based, for instance, in our case study in Spain, he will also have to respect then the EU rules on the gathering of evidence. So it can be, for the expertise, it can be a possibility to appoint a foreign expert based on his expertise. But please take into account that this expert will always have to follow also the Belgian rules and also the EU rules. So this is something that you cannot avoid.
Yeah, and the language also is, or
and the
might
language
be.
that's very important, Annick, indeed. If he is appointed, for instance, by the Antwerp Commercial Court, the court expert proceedings will have to be conducted in Dutch. So he will have to find then a foreign expert, maybe of the Spanish nationality, who also speaks Dutch then, in order to, because the defending party will insist on that.
There's another angle to that. There's another angle, if I may add. I mean, experts are often appointed by insurance companies, of course. I mean, if you notify a claim, the first thing an insurer will do is usually to appoint an expert rather than a lawyer. And the expert needs to advise the insurance company then on what has happened, technically what has happened, and what is the likelihood that the insured is effectively liable. And if so, what sort of amount needs to be reserved as compensation for his liability. In practice, what we see, if in case of product liability insurance funds, is that these experts will start to work together also with the insured in preparing technical defense, which is a good thing because it adds knowledge to the table. But my preference is that as soon as you know that the litigation on the merits is not going to take place within Belgium, within your own jurisdiction, but in a foreign jurisdiction, and that you have a need to involve local experts as well, because of language reasons, but also because of the fact that if you end up in litigation in front of a German court or a French or an Italian court, and you do not show up with a local expert with some reputation in that market, in itself, it may already weaken the credibility of your case. How good your expert may be, but if a judge sitting on his bench recognizes someone as an expert who already appeared on dozens of occasions beforehand, it's a human matter that this may add and improve the credibility of the position that you want to defend and take. And that is why I think that although technical knowledge is rather uniform and omnipresent rather than legal knowledge where you are bound by the boundaries of a particular jurisdiction, for tactical reasons, I still prefer to involve local experts from the country where the dispute on the merits will be conducted.
Yeah, thank you. It's correct, of course. And there was another question for you, more typically, because then,
yes.
yeah, the language issue is quite also sensible, of course, since I say that I win a case just on this issue.
Yes.
Can you? Yeah.
Yeah, I saw the question coming in, and the question is maybe to share it with the audience then, that if you are a Dutch company and the other party is a German buyer, the Dutch company hired German lawyers also, is it reasonable to demand all evidences to be translated in English? And is litigation totally in English possible before German courts? I think in a dispute, of course, we can only advise under Belgian law and proceed before Belgian courts. But based on our experience, I think in the proceedings between a Dutch company and a German company, it depends, of course, on the legislation in the Netherlands and Germany. But I don't think that it makes sense to demand a translation in English. I think it will be either, if we compare it also to the Belgian legal system, it will be either before the Dutch court a translation to Dutch, or before the German courts a translation of documents to German, and that not everything which will be held can be translated in a third language, unless that the parties have included an arbitration clause in their contract, which refers and also to English as the applicable language. And the question is, litigation totally in English possible before German courts? The proceedings that I have been have witnessed before the German courts, or was party, or one of the clients was party, there also, I think the German courts, also the proceedings are conducted in German. we'll have to verify whether also there are specific language requirements. There's a language law which also stipulates, like in Belgium, that the proceeding should be conducted in German. And I think also that the rules are the same as here in Belgium, that unless that it's stipulated that it's permitted to have court proceedings in English, that you can only have arbitration in English, but maybe some other participant knows the answer, or German lawyer, but I think that it will be most likely also the proceedings should be conducted in German.
Yeah, we
know the
talk
situation.
a lot.
Yeah.
Sorry.
Sorry, Annick, I just wanted to add to you, I don't know the situation in particular about Germany, but I do understand that in certain Dutch courts, it is possible to conduct litigation in English language. You remember that the former Minister of Justice also had the intention to create a sort of business commercial court in Brussels. Ultimately, it has never been created. So we don't know this possibility in Belgium. And as you all said, this is something that parties need to think about at the level of their contract management. Yeah, not at the moment that the dispute arises, but ideally beforehand. And if language is paramount to your company, and also language when it comes to litigation, then the best option there is to choose for arbitration and to put in the arbitration clause very clearly that the arbitration proceedings shall be conducted in English language, which in any sensible commercial jurisdiction is a valid clause.
Yes.
Yeah. That's
Correct.
what I wanted to refer to this. There was a few months ago really a competition between the EU member state, and each of them wanted to have the English proceeding court, which was a little bit a flop, I would say, afterwards, when they realized all the challenges that they have to come through, in particular from proceeding rules and the law to be adopted.
Yes,
so,
that's absolutely right. And also, as Hugo pointed out, in the Netherlands and Amsterdam, you have the International Business Court. Maybe also some International Business Court in Frankfurt that also permits that then proceedings will be conducted in English. But I think in order that this court will have jurisdiction, they should be explicitly appointed in the agreement, and otherwise I think it will not be possible to go before this court unless both parties agree on it.
Okay, thank you. But I think that we are basically close to the end, and I guess that Bruno, you may want to add something, or just...
No, I would like to thank all the participants for joining this seminar co-organized with Lydian, and I will invite all of the participants to research the ACC Europe website, because we are closing a year 2021, a bit of an hybrid one, and we will be soon opening the year 22, where we will still offer you some conferences available on the ACC Europe website. So the next stop is really to already start looking for interesting, I would say, continuous education experience with ACC and with our partner law firm, including Lydian. So with that, I thank you, each of the panelists, Annick, Hugo, Kim, and Yo, and I'm looking forward to see you next year for additional content. And with that, I wish you a good afternoon and a good week.
Thank you,
everybody.
Bruno. Have a nice
Bye-bye.
afternoon, everybody. Bye-bye.